Good morning, and we want to welcome our third panel. The ranking member is going to have to leave us briefly, but is planning to return, so thank you all so much for being here. Ms. Hannah Freed is the director of All Voting is Local, a collaborative housed at the Leadership Conference Education Fund in conjunction with the American Civil Liberties Union Foundation, the American Constitution Society, the Campaign Legal Center, and the Lawyers Committee for Civil Rights Under Law. Ms. Freed has run voter protection efforts for 2 presidential campaigns and spent several years in federal government services at the Department of Justice and the Environmental Protection Agency. Welcome. I know I'm not doing this in order, but Ms. Barbara Arnwine, how are you, Ms.? Is the National Co-Chair of the National Commission for Voter Justice. Ms. Arnwine is also the president and founder of the Transformative Justice Coalition and served as head of the Lawyers Committee for Civil Rights Under Law from February of '89 through June of 2015. Ms. Arnwine is renowned for her contributions on critical justice issues, including passage of the landmark Civil Rights Act of 1991 and the 2006 reauthorization of provisions of the Voting Rights Act. Welcome. Denise Lieberman is the Director of Advancement Projects Power and Democracy Program and a senior attorney. Ms. Lieberman works to identify and remove systemic barriers to voting. A seasoned constitutional and civil rights lawyer, Ms. Lieberman works on the ground in Missouri in addition to advancing broad voter protection initiatives nationwide, engaging in political analysis, lobbying, legal advocacy, litigation, and community building to advance electoral reform, including spearheading a nationwide advocacy effort to combat repressive voting legislation this past year. Welcome. Ms. Kase serves as the Chief Executive Officer of the League of Women Voters in the United States, where she is leading the organization through a period of rapid transformation and growth, focused on building power by engaging in advocacy, legislation, litigation, and organizing efforts centered around issues of voting rights and democracy reform. Prior to joining the League in 2018, she served as COO of Kase, an organization at the forefront of the immigrant rights movement representing nearly 100,000 members. As you know, you will see a lighting system in front of you. When you begin, the light will turn green. When you have 1 minute left, you will see the yellow light, and when you see the red light, please prepare to wrap up. Ms. Freed, you are recognized for 5 minutes.
Thank you. Chairperson Fudge and members of the subcommittee, I'm Hannah Freed. I'm the campaign director for All Voting is Local, a collaborative campaign of the Leadership Conference Education Fund. We fight to eliminate discriminatory barriers to voting before they happen. Since 2018, we've worked in Arizona, Florida, Ohio, Pennsylvania, and Wisconsin. Thank you for the opportunity to testify. Our election system is broken. In 2016, problems at the polls prevented 1 million voters from casting a ballot. These problems disproportionately harm voters of color, young people, low-income Americans, and voters with disabilities. In the past 2 decades, Congress has recognized the need for strong federal protections for the right to vote, passing the Help America Vote Act in 2002 and reauthorizing the Voting Rights Act in 2006. Both passed with strong bipartisan support and a robust record. Despite this, in 2013, 5 Supreme Court justices gutted the critical protections of the Voting Rights Act Section 5 preclearance system. Since the Shelby case, states and localities across the country have erected barriers to voting without critical safeguards. Federal protections for voting are as vital today as they have been for the past century. The 2018 elections were lauded for record turnout, but eligible Americans voted at a rate of less than 50% and faced insurmountable obstacles. State officials purged voters from the rolls, sometimes simply for not voting. From 2010 to 2018, Georgia's Secretary of State, now Governor Brian Kemp, purged more than 1.4 million voters. Worse still, some states are more committed to purges than to ensuring an accurate list maintenance process. In 2018, Georgia's exact match law put into question the registration status of 50,000 voters over minor inconsistencies in their registration records. Just recently, Ohio's Secretary of State admitted their purge system was rife with errors. Just shy of 500,000 Ohioans, many of them African American and low-income voters, will be purged this year under this flawed system. In 2018, voters faced large-scale polling place changes. The Leadership Conference Education Fund's Democracy Diverted report found that in former Section 5 states, there were 1,173 fewer polling places in 2018 than in 2014, despite last November's record turnout. Maricopa County, Arizona, 31% Latino, closed 171 polling locations after 2012, the most of any county studied in the report. Widespread polling place changes lead to the overuse of provisional ballots. Our campaign's analysis of 717 former Section 5 counties found that voters in counties with more polling place closures are more likely to be asked to cast a provisional ballot. HAVA contemplated that provisional ballots would be used as a fail-safe, but they are less likely to be counted than a regular ballot. Their overuse is the canary in the coal mine, signaling systemic problems that result in voters not knowing where or how to vote. Our campaign's analysis of provisional ballot usage has found strong connections to race. In Pennsylvania, voters in Philadelphia County, 41% African American, are 5 times as likely to get a provisional ballot than voters in Allegheny, 12.7% Black, or Berks, 4% Black. In 2018, African American students face unique barriers to voting. At Ohio's 2 HBCUs, voters cast a disproportionate number of provisional ballots and were twice as likely to have their ballots rejected than voters countywide. In Florida in 2018, Florida A&M University, the state's sole public HBCU, was the only major public campus without an early vote site. In 2018, voters of color were more likely to have problems voting by mail. An analysis by All Voting is Local of our states found that voters in mostly white communities are less likely to have their mail-in ballots rejected than voters living in communities of color. In Arizona, just over 1% of Native American voters are on the state's permanent early voting list, compared to approximately 80% of non-Native American voters. In 2018, strict photo ID laws targeted African American voters with almost surgical precision, as the Fourth Circuit in 2016 wrote of North Carolina's law. Last fall, our campaign helped hundreds of Wisconsin voters through the arduous process of complying with that state's strict photo ID law, a law that has been found to deter from voting more than 20% of African American registered voters, compared to 8.3% of white registrants. Election administration practices can and should be used to expand access to the ballot for all eligible Americans. Too often, they instead become a barrier to voting, disenfranchising millions of eligible Americans, particularly voters of color. Any wrongfully disenfranchised voter is one too many. Congress must restore and expand safeguards of the right to vote, ensuring that every eligible American, regardless of race, income, age, or ability, can make their voice heard. Thank you.
Thank you very much. Ms. Kase, please. 5 minutes.
Chairmanwoman Fudge, Ranking Member Davis, and members of the subcommittee. My name is Virginia Kase, and I serve as the Chief Executive Officer at the League of Women Voters of the United States. Thank you for the opportunity to testify today on voting rights and election administration in America, an issue of paramount importance to our organization. The League of Women Voters is nonpartisan, founded nearly 100 years ago in 1920 by women who understood the importance of securing voting rights for women. The League is active in all 50 states, as well as the District of Columbia, with 764 local affiliates in every congressional district in our country. In 1965, the Voting Rights Act outlawed racial discrimination in voting and established procedures to protect equal access to the vote for everyone. Despite a long history of support from legislators of all political parties, in 2013, the Supreme Court overturned key provisions of the VRA in the case of Shelby County v. Holder. Since that decision, politicians across the country have passed unnecessarily restrictive legislation and adopted practices that discriminate against and disenfranchise voters of color and minorities whose first language is not English, making it harder for them to register and much more difficult to vote. These restrictive legislative initiatives included efforts to implement photo ID requirements in states like Texas, Wisconsin, Missouri, and Pennsylvania. The League pushed back against efforts to roll back early voting hours in Ohio, and we pushed back against efforts to roll back and eliminate pro-voter reforms like pre-registration and same-day registration in North Carolina. Essentially, the Shelby decision weakened the Voting Rights Act as a mechanism to fight discrimination by striking down important pre-clearance and oversight provisions. These suppressive laws have a major impact on our elections. Excessive long lines in urban areas where minorities reside, consolidation of polling sites with little or no notice, reduction in early voting hours that limit participation, massive voter purges with no effective notice that cause registration barriers on Election Day, and inadequate numbers of machines in areas where early voting showed a clear influx in voter participation. And because these issues repeatedly show up in areas with large minority populations, in states like Georgia, Florida, North Carolina, Arizona, Michigan, Ohio, and Texas, it is unlikely that this scheme was incidental or unintentional, but instead expressly targeted the growing population of the new American majority, including minorities, youth, and income-sensitive individuals. In effect, these suppressive laws shut out millions of the new American majority and denied citizens the protection of their right to vote. With these minority-targeted voting barriers road-tested, the 116th Congress has a momentous opportunity to restore voting rights in this country. The opportunity to strengthen the Voting Rights Act by creating a new formula that would trigger pre-clearance of certain changes to voting laws and administrative practices is needed now more than ever. And the creation of a national notification process that lets all voters know when changes to election processes may occur ensures that voters are informed prior to them showing up to the polls on Election Day. If Congress fails to act immediately, this will be the first redistricting cycle to occur without a fully functioning Voting Rights Act, and will allow states to push through unjustifiable changes to their laws that will have a direct impact on voters for a decade. Without continued oversight and safeguards in place to protect voters from all backgrounds, it is left to organizations like the League of Women Voters and other nonprofit voting rights groups to inform and protect voters affected by these policies and practices. But that should not be the sole role of the League and our partners. It is the responsibility of government to create and enforce laws that prevent barriers in the democracy our forefathers designed to foster an open, transparent government powered by the people, for the people, all of the people. It is the duty of government to protect the rights of voters and to encourage participation in our political system, not create barriers that prevent participation. As we have for nearly 100 years, the League looks forward to working across the aisle to determine the points of consensus for any and all voting rights legislation considered before Congress. And we look forward to working with elected leaders to protect and uphold their responsibility of ensuring voters have the unobstructed ability to exercise their right to vote. Thank you again for the opportunity to testify on the importance of restoring the Voting Rights Act, and I look forward to taking questions and continuing to work with you all on this important issue.
Thank you very much. Ms. Arnawine, you are recognized for 5 minutes.
Thank you, Chairman. The subcommittee, thank you for the opportunity to testify today on this important topic. I want to dedicate my remarks, of course, to the memory of Congressman Elijah Cummings. My name is Barbara Arnwine. I've already been introduced. I am here representing the National Commission for Voter Justice, which was conceived by Reverend Jesse Lewis Jackson Sr. He's represented here today by Reverend Todd Yeary of Baltimore. And I want to make sure that we get this into the record that this commission was formed in July 2017 to respond to the myriad of voter suppression measures in the post-Shelby versus Holder era. Also, many will recall that President Donald Trump's manifold assertions post-election of pervasive voter fraud and his subsequent creation of the now-defunct Presidential Advisory Commission on Election Integrity. We felt there was an urgent need instead to counteract his dangerous and erroneous narrative and instead provide a truthful account of the urgent need for the protection of our democracy from the insidious threat of the modern era of voter suppression. I created the map of shame in April of 2011, which was the first national tool to expose and educate the American public about the rise of contemporary voter suppression measures. Since I released the map of shame, there has been erected a formidable and substantial regimen of disenfranchising barriers to the ballot box and to the ability to have the votes counted for millions of eligible but vulnerable voters. Since its launch in January 2018, the Commission has held a series of hearings, compiled over 14 state reports looking at voting rights, and has engaged in many voter education and other efforts. One thing that we heard in June of 2018 from Professor Donald Jones of the University of Miami was that when the only real proper way to look at what this era that we're in is understanding that when it comes to voting rights, America is facing its second civil war. That's how extreme this period is. This reality of an active war against the rights of American citizens to exercise their right to vote and have their votes counted is supported by mounting evidence when we consider the myriad of voter suppression laws passed in the states, the multitude of voting rights cases filed in the state and federal courts, the numerous reports documenting actions by the states which have impaired the rights of citizens to vote and have their vote counted, and the continuing negative cases from the Supreme Court and the new insidious threat of Russian use of social media as documented by the Select Senate Commission investigation report. We also have created a new tool and document that is called the 61 Forms of Voter Suppression. And let me be very clear that a year ago, this was less than 30. That the creativity, the insidiousness, the rapid expansion of voter suppression measures is that extreme, and it's growing. If I were to do this today, I would probably add 4 more. That just shows you how creative these states are being and how persistent they're being in pursuing this. Our major findings of our hearings have been already expressed by some of the testimony, but I just want to make clear one point. I mean, there are 2 really critical things that we need to appreciate today. One is that when Shelby versus Holder was decided, we were only 18 months into the regimen of modern voter suppression. We are now 8 years deep into this regimen. And the Congress now knows a lot more than the Supreme Court knew back in 2013. So you have substantially more evidence about the impact of the absence of a pre-clearance mechanism. The second thing I want to make clear is that nothing in the world can substitute for pre-clearance to prevent racial discrimination, and that in this era of massive voter suppression, that this clumsy and ineffective regimen that exists is not enough. So we want to commend the Congress. We want to commend you for this hearing. We have things we would like to move into the record. The testimony of Reverend Jesse Jackson, the 61 forms of voter suppression, and of course I would like to expand my remarks. Thank you so much.
Thank you. With no objection, so ordered. Thank you very much. Ms. Lieberman, you are now recognized for 5 minutes.
Thank you, Chairman Fudge and members of this committee for holding this important hearing today on voting rights and election administration. My name is Denise Lieberman. I'm the Director of Power and Democracy at Advancement Project National Office. Advancement Project is a national racial justice organization that works in deep partnership with grassroots organizations to develop community-based solutions that are inspired by the tactics that produced the earlier landmark civil rights victories. We are proud to stand behind our many partners on the ground in the states who are fighting battles for racial justice and the right to vote. And the need is great. We are faced today with the greatest battle for the solvency of our democracy since the post-Reconstruction era. I'm particularly gratified, Chairwoman Fudge, that this subcommittee has chosen to have a people's panel, because our fight to protect the right to vote and the need for Congress to take definitive action to secure the right to vote for all citizens lies in the lived experiences of the people for whom protection is most needed and the people whose voices are most often silenced. Because at the end of the day, the right to vote is about self-determination, the right of people to make decisions about their own lives and their own destinies. It is about dignity. It's society's structural mechanism that says you count, literally. And so when the right to vote is denied or abridged, it says you don't count. And so this is a very, very personal matter. As much as it is policy, it is legal, and we need to understand all of these statistics, it is deeply rooted in the basic human dignity of all people. And we also know that any remedial actions that this body takes are going to need to be justified in legal challenges based on the record of the lived experiences of the people who these measures impact most. So Advancement Project has been pleased to work in collaboration with other members of the Racial Equity Anchor Collaborative to support this subcommittee's field hearings that you've held over the last 8 months, documenting the state of voting rights in jurisdictions around the country. The Anchor Collaborative members, which include Advancement Project, Asian and Pacific Islander American Health Forum, DEMOS, Faith in Action, the NAACP, National Conference of American Indians, the National Urban League, Race Forward, and Unidos US, are all dedicated to advancing a voting system that is free, fair, and accessible to all people, regardless of race, ethnicity, ability, or language proficiency. In addition to helping identify leaders on the ground to testify at this committee's field hearings, the Anchor Collaborative partners embarked on a robust grassroots effort to lift up the voices of everyday voters of color and their experiences. So to complement the field hearings, we conducted a series of people's hearings in select states to gather firsthand accounts of voter suppression. And through the creation of a website, We Vote, We Count, where voters across the country can share their voting experiences. We held hearings in states like Alabama, North Carolina, Ohio, North Dakota, South Dakota, Georgia, Florida, and Texas, and heard from voters firsthand. Witnesses there attested to, among other things, having to wait in long lines to cast ballots, being denied bilingual ballots or language assistance at the polls, being denied disability assistance at the polls, having to restore their registration status after an illegal purge, undertaking onerous barriers to restoring their voting rights after a criminal conviction, having to stand up to last-minute changes to polling locations and hours of operation, rampant misinformation, and voter intimidation. The reports also capture the impact of voter ID laws, the cuts to early voting, the increasingly scarce polling places and ever-changing locations, which present significant burdens for those without easy access to transportation or inflexible work schedules. And the results were clear. Since the loss of federal oversight in the post-Shelby era, voters of color across the country are confronted with renewed barriers to casting a ballot. We've documented these reports in a soon-to-be-released report called We Vote, We Count, the need for congressional action to secure the right to vote for all citizens, which includes testimonies from African Americans, Asian Americans, Native Hawaiian, Pacific Islanders, Hispanics, and Native Americans, whose firsthand accounts provide a glimpse into the inner workings of actual access to the ballot around the states and compel this body to take action to restore the preclearance provisions of the Voting Rights Act. What we saw around the country is that voters have lost confidence in the wake of the Shelby decision in the ability of the Department of Justice to fairly secure their right to vote. And so we know that the Shelby decision emboldened attacks on the right to vote, not just in the former preclearance states, but around the country, designed to curtail the growing political power of voters of color as they emerge into the new American majority. And so we thank you today, Congresswoman Fudge and members of this committee, for holding this hearing. Please heed the words of these voters across the country and take action to secure federal protection for the right to vote. Thank you.
Thank you. Thank you all so much. Mr. Aguilar, you're recognized for 5 minutes.
Thank you, Madam Chair. Thank you to the panelists. Ms. Lieberman, I'll start with you, and then we can kind of work our way down because you spoke about barriers and your new report. Can you talk to me about some of the most common barriers. We've taken testimony and we've gone around the country and we've seen, quite a few. Talk to us about what your research tells you are the barriers that you often find, but also specifically if the panel can talk a little bit about vulnerable and emerging populations and the types of barriers that those constituencies face.
Absolutely. And what we saw was that voters were reporting difficulties at every step of the process, from registering to vote, to casting a ballot, to having those ballots counted. We've seen a rise in discriminatory voter registration procedures, onerous processes for being able to register to vote, particularly onerous processes for people who are attempting to restore their rights to vote, either after an illegal purge or after having their rights suspended due to a felony conviction. We just heard, for example, last week in Louisiana during early voting from voters who, despite having gone to numerous government agencies in the wake of last year's passage of Act 636, which restored voting for people with felony convictions who have been out for 5 years, were still not able to cast a ballot despite having jumped through numerous hoops and hurdles. Those hoops and hurdles were pervasive throughout the processes that voters described, through polling place closures and changes, to having to drive numerous hours. Witnesses in Alabama testified to the closure of over 30 DMV locations in disproportionately African American and poor counties after that state enacted a voter ID law, causing people to have to drive sometimes up to 4 hours to get to a process. I could go on and on, but these populations are significantly impaired. In North Dakota, a witness testified to, in a county that has a 36% poverty rate, the barriers of people having to drive numerous hours just to get all the underlying documents, to get the IDs in order to vote under that state's ID law. So what we found is that they're pervasive throughout the voting process.
Yes, we found that the populations that we looked at were, the populations we looked at were African Americans, Latinos, Native Americans, Asian Americans, low-income voters, voters with disabilities, student voters, formerly incarcerated persons, newly naturalized citizens, voters displaced by natural disasters, and homeless voters. These are some of the most vulnerable voters, and they are really bearing the brunt of the voter suppression. And by our calculation, millions of voters have been denied or blocked from voting who come from those categories, not to mention those who are LGBTQIA and may have changed their identity, name, or sexual identity. We found that of the measures, the 61 forms captures a lot of these measures, because that's how many there really are. There's so many more. But most of the ones that you've already heard, some of them, such as our witnesses talked about targeted poll closures, exact match requirements for registration and for counting absentee ballots. The refusal to place polling sites on student campuses, which is now a big fight again in Texas. But that was a huge issue in Florida, and coming out of our hearing, there was a lawsuit filed that challenged the refusal to put polling places on student campuses in Florida for early voting, and they won it. And they were able to have those polling sites in 2018. We also heard about voter caging, especially in Michigan, and in many other states, Texas, Alabama. Voter purging, that was one of our first hearings that we really started realizing up front. By the third hearing, we knew that voter purging was a huge problem in our country. And I still think that realistically, the ability to intercept and fight voter purging has been one of the weakest parts of our community's ability to respond. And it is problematic because it's widespread and there's many states where there's no activity going on to stop it. Onerous voter ID, failure to follow state procedures like we saw in South Carolina, where they failed to follow their own procedures as to staffing of polling places, resulting in literally some of the longest lines in, targeted minority neighborhoods. We also saw abuses of provisional balloting, disparate impact between white and people of color jurisdictions created by the failure to provide adequate election equipment and staffing, racial gerrymandering, cuts to early voting.
Ms. Arnwine, I'm going to have to cut you off.
Yes, okay, but I just want to, he asked me.
If you want the other two to quickly answer, we can.
Yes.
You could, Ms.
Sorry.
Yeah.
Thank you.
Yes.
So I will go quickly. Just a few examples in addition to the ones that have been cited. For example, when we see people who have finally become re-enfranchised after being incarcerated, there are additional attacks on that by requiring them, for example, in Florida to pay fines or restitution in order to be able to do that. So every single time you see that we try to overcome these barriers, there are new ones that are put in people's places. Recently, we had a Supreme Court decision, Russo v. Common Cause. The League of Women Voters was part of that case. And we now are very concerned that we are going to see racial gerrymandering disguised as partisan gerrymandering because there has basically been a green light for that. We have seen broken down election equipment. The League is on duty every election day. We are looking in every congressional district, looking at seeing what is happening on the ground. We had 6-hour lines in Georgia because of broken down voter equipment. And we are doing rapid response. It should not be the responsibility of nonprofit organizations like ours to have to do rapid response because the government is not doing what they're supposed to be doing to enfranchise voters. Senior citizens, rural communities, minorities and youth, all having difficulties accessing IDs. Third-party voter registration criminalization, like what recently happened in Tennessee, that we were able to fight back and combat once again. And so it's just these constant attacks that communities are facing, and we, organizations like ours, are being responsible for addressing these.
Thank you, Ms. Hayes. Ms. Freed, I'm so sorry.
Thank you. And just by the way, did you know that the director of the League of Women Voters was on the purge list in Ohio?
Yes, I did, and we've had many situations like this. One of the oldest voting rights organizations in the country, and we're not immune.
Ms. Freed, if you want to answer very, very quickly, I will let you.
I will. Thank you. What I'd like to highlight from what my fellow panelists have said is that the problems that American voters are facing are not singular, they're stacking. A voter who has a problem getting a voter ID, then gets to the polling place, has to drive miles to get to their polling place, then there's a line at the voting location. These problems are not singular in their origin, and our solutions, our response to them needs to be across the spectrum. There need to be both federal statutory protections as well as state administrative protections, laws and practices that expand access to the ballot, particularly in communities of color.
Thank you. Thank you. Let me just for a moment, just pretend that I'm Justice Roberts. And I'd just like for you to make the case as to why we should fully reinstate the Voting Rights Act and what you think the pre-clearance formula should look like, if you have any idea. We're going to start at your end, Ms. Freed.
Thank you. Between 2013 and 2018, there were almost 1,700 polling places that closed in former Section 5 jurisdictions. The Leadership Conference released just earlier this fall a report discussing these changes. 75% of those happened between 2014 and 2018, despite the increase in turnout in 2018. Voter suppression is pervasive. Voters in this country face extraordinary barriers to the ballot. Our ability to vote, the ability particularly of communities of color to vote, is frankly miraculous in light of the barriers that they face. This is especially true in former Section 5 areas. Poll closures, voter ID laws, a lack of access to early vote, particularly in communities of color, restrictive hours of early vote. These problems are widespread and they are pervasive, and we aren't seeing the kinds of improvements to them that we need to be. What preclearance allowed us to do was to understand not only that changes are happening, but the impact that they have. Without preclearance, we can't understand fully the impact on communities of color of these changes. It's absolutely vital that preclearance be restored.
Thank you, Ms. Kase.
If you were Justice Roberts. I would say that we have three bodies of government for a reason, and that the Supreme Court's job is to serve as a representative of the American people. And when we see people's rights being violated time and time again, and the most fundamental right that we have as citizens of this country is our right to vote, to have our voice heard, that the Supreme Court has a responsibility to protect that right so that every citizen is considered equal. We talk about equal under law. We should be equal in the ballot box. And it means removing barriers for each citizen to exercise that right. But I would say that there are already remedies that you all have in place that have been proposed. And one of the ones that we are really in favor of is the formula under Representative Sewell, which is statewide having 15 or more violations over the past 25 years, at least one of which was committed by the state itself. In political subdivision, 3 or more violations during a calendar year. Voting violations of the 14th or 15th violations. I mean, you have all of this information yourself, so I don't want to waste too many people's time because there is just too much to read off. But the formula is here, and we support these formulas, and we think that Congress must act. You must act now because we are coming into very serious elections this coming year.
Just ask you this question. Most of what you are talking about really goes back to the original, 14 or so jurisdictions. But what about states like Ohio that was not covered under preclearance? What about states like Pennsylvania and Wisconsin? One of the things that the Supreme Court was concerned about is that they were determined to say that that is such an old record and the data is so old that we can't prove that they should still be held to the same standard of preclearance. But I think that the situation is worse and it is bigger. So what do we do to include those new jurisdictions?
We need to, first of all, do a better job of tracking what is happening so that we can ensure that it is a living and breathing process, meaning that it doesn't end after a certain amount of time, that on an annual basis we are able to look at where there have been violations and ensure that those protections are in place where we are seeing them happening. And yes, you're right, it's expanded. It hasn't gotten better, it's in fact gotten worse. Since 2013, we've seen that time and time again.
Thank you. Ms. Arnwine.
Yes, Chief Justice Roberts. Court. First, in the Shelby decision, you spoke very powerfully about the fact that we all recognize that there still exists discrimination in voting, and you felt that Congress had not, quote, done its job. Since then, Congress has been very keen of looking at what are, in fact, the modern day conditions that exist between the states and among the states when it comes to voter accessibility and voter fairness. What we know at this point, in this 8 years that have occurred since 2011, is that the states that were previously covered by preclearance have, in fact, had some of the worst records for not only poll closures, but for purges, that literally millions of voters have been affected by that those voters deserve the coverage and the protection of our laws, of our country, should not have to be subjected to that voter denial before they're able to have their votes counted properly. That when you also have you have told this Congress to come up with a new set of coverage formula. And that coverage formula is designed to look at those violations that are the most extreme, that deny the most voters their rights to participate. Since your directive to Congress, we have held hearings, we have compiled and looked at reports of what's happening in the states. We are able to come up with a formula that captures for preclearance the states that are engaging in the worst activities. But at the same time, we also have recognized that in this modern era, we got to come up with some additional new standards, that we just can't look at voter turnout anymore. We can't look at some of the old original Kassenbach standards. That instead, that what we need to look at now is to make sure that there's better notice provisions, to make sure that on a national scale, as you were concerned, that states are able to be held accountable. We believe we have done our job, and that you should uphold our new legislation.
Thank you very much. Ms. Lieberman.
Justice Roberts. I agree with everything my fellow panelists have said. And, you know, the writing is on the wall here. I mean, in the first year after the Shelby decision came down, 73% of the previously covered jurisdictions introduced restrictive voting laws. New restrictive voting laws have been introduced in 25 states since 2010. Right, and we've seen through the stories of individuals that Shelby has emboldened not just the former pre-clearance states, but states around the country to continue to make voting harder, more confusing, more onerous, and more burdensome. But not only that, not only did Shelby open the door to discriminatory practices that would have been halted at the outset under preclearance, but it's also made it more difficult to challenge those laws, unduly placing the burden on already underrepresented voters of color and their advocates. So since Shelby, without the law's stopgaps, the evidentiary burdens and the costs associated with these challenges has fallen even more heavily on the very impacted communities that these laws are designed to protect, to challenge denials of their fundamental right to vote. And so it's very clear that that is simply not tenable. It's not working. Congress has the opportunity right now before it with H.R. 4 to implement federal voting protections, to place the burden where it should be on the backs of the government agencies that are seeking to implement new restrictive voting changes to show that they're not discriminatory.
Well, I think you all can represent me anytime. I thank you all so much for being here, and I thank you for your testimony. Thank you so much. The other panel, I don't think, has arrived yet, right? Okay. They're on their way over. Thank you all again very, very much.